Okay, welcome everybody to the Committee of Adjustment meeting. The committee will hear applications for minor variances and consents. We'll call each application by name and number, and we'll ask if anyone wishes to speak regarding an application. Give their name to the secretary so it can be recorded, and then we'll give you that opportunity. The applicant and the agent will automatically be notified of our decision in writing. If anyone else wants a decision in writing, you'll have to sign up at the clipboard at the back of the room so that we will send it to you in the mail. There is a 20-day waiting period after today's decision before the decision is final in order to allow for appeals. And other than that, just make sure we push the button when we want to speak into the microphone so we can hear you, and smile for the cameras. Is there any disclosure of interest by any committee members? No. I have a motion here. It's been moved by Larry and seconded by Dennis, and resolved that the minutes of the Committee of Adjustment meeting held Wednesday, January 16th, 2019 be adopted as circulated. Any errors or omissions? Those in favor? That one's carried. Our first two applications on the agenda today are AN 317 and BN 318, P&S Van Berlo Limited. Is there anyone here for this? No? Okay. Go ahead then.
To the committee, these two applications have been deferred at the applicant's request, so they'll be brought forward at a later Committee of Adjustment meeting.
Okay. I just wanted to make sure no one was here. So that's good. So we'll need mover and seconder. So for application AN 317, it's been moved by Marcel, seconded by Dan, that we defer the application at the applicant's request. Those in favor? Carried. And BN 318, it's been moved by Rudy, seconded by Eric, that we defer this application at the applicant's request. Those in favor? Carried. Thank you. I gotta do some stuff here. Okay, so our next application in that case is BN 330 and Till Valley Farm, Inc. Is there anyone here for this application? Okay, you are. Anyone else? We'll have the planner explain the report then.
This application is to sever a 1-acre parcel containing a dwelling made surplus through farm amalgamation. The subject lands are located on the east side of 4th Concession Road E&R in the former geographic township of Houghton. The lands contain a single detached dwelling and a detached garage. The subject lands are part of a larger farm parcel containing a barn and the partial foundations of a greenhouse and 2 kilns. The lands are surrounded by agricultural uses. The proposed lot accommodates services and does not remove farmland from active production. Staff support this application and recommend that it be approved, subject to the attached conditions.
Thank you very much. Any questions of the planner? Marcel? Okay, thank you. I'm sure it was there for a while anyway. So I have a motion by Marcel, seconded by Eric, that the committee approves the application to sever a parcel with a frontage of 45.9 meters, a width of 45.9 meters, a depth of 89.7 meters, and an area of 4,047 square meters, or 1 acre, and retain a parcel having an area of 40 hectares as a severance of a dwelling made surplus through farm amalgamation. Excuse me. The application is consistent with the provincial policy statement and the Norfolk County official plan regarding surplus farm dwellings, and no public input was received, therefore not considered as part of the application. And of course, the conditions are outlined in the motion as well. So is there any further discussion? And those in favor of the motion? That motion's carried. Thank you. Our next application is BN 324 Allen and Virginia Van Lowe. Is there anyone here for this application as well? Okay. Anyone else? Oh, sorry, can't see, sorry. And you are? Okay. We'll have the planner explain the report then.
This is an application to sever a 0.82 acre parcel containing a dwelling made surplus through farm amalgamation and to create a hydro easement in favor of the subject lands. The subject lands are located on the north side of 12th Concession Road in the former geographic township of North Walshingham. The subject lands contain a single detached dwelling and a detached garage that are part of a larger farm parcel that contains another detached dwelling that is also proposed to be severed as part of another application. The lands are surrounded by agricultural uses. The proposed lot accommodates services and does not remove farmland from active production. Staff support this application and recommend that it be approved, subject to the attached conditions.
Thank you. Questions of the planner? I have a motion by Rudy, seconded by Larry, that the committee approves the application to sever a parcel with a frontage of 41.4 meters, a width of 41.4 meters, a depth of 84.1 meters, an area of 0.33 hectares, retaining a parcel having an area of 98.5 acres as a severance of a dwelling made surplus through farm amalgamation. The application is consistent with the provincial policy statement and the Norfolk County official plan regarding surplus farm dwellings, and no public input was received, therefore not considered as part of the application. And again, the conditions are outlined in the motion. Is there any further discussion? Those in favor? Carried. Same applicant, different number, BN 325.
This is an application to sever a 0.74 acre parcel containing a dwelling made surplus through farm amalgamation. The subject lands are located on the north side of 12th Concession Road in the former geographic township of North Walshingham. The subject lands contain a single detached dwelling and are part of a larger farm parcel that contained another detached dwelling from the last application. The lands are surrounded by agricultural uses. The proposed lot accommodates services and does not remove farmland from active production. Staff support this application and recommend that it be approved subject to the attached conditions.
Thank you. Questions of the planner? Dennis? Okay. I have a motion by Dennis, seconded by Eric, that committee approves the application to sever a parcel with a frontage of 36.3 meters, a width of 36.3 meters, a depth of 83.5 meters, an area of 0.74 acres, and retain a parcel with an area of 98.5 acres as a severance of a dwelling made surplus through farm amalgamation. The application is consistent with the provincial policy statement and the Norfolk County official plan regarding surplus farm dwellings, and no public input was received, therefore not considered. And the conditions are outlined as well. Is there any further discussion? Those in favor? Motion's carried. Our next application is BN 332, Bill and Selena Thompson. Is there anyone here for this application? Welcome. Anyone else for this one? We'll have the planner explain the report then.
Good afternoon. This application is for lands located at 329 St. John's Road, which is located on the north side of the road. The property is to sever a 16 hectare parcel and retain approximately 37 hectares to correct a land titles issue where the properties were inadvertently merged on title. There was no comments or concerns raised by any of the public. However, planning staff are recommending refusal of the application as it's technically creating an additional lot and does not meet the provincial policy or the Norfolk County official plan. Thank you.
Is there any questions of the planner? Dan?
Yes, Mr. Chairman. Do we know when it was inadvertently merged?
Through you, Mr. Chair, it's been a number of years. I believe Mr. Colomea can speak more specifically to some of the title issues that are associated with the property.
Would you like to join us, sir? Sure.
Through you, Mr. Chair. The merger occurred in the early 90s, I believe about 1994. What had occurred was Mr. Smythe held one of the properties, and then he received the second property, which resulted in the merger as a result of an estate transfer. He was the sole beneficiary of this particular will, so the estate transfer was the cause of the merger back in approximately 1994 when it was back in registry.
Yes.
Yes, Mr. Chairman. Mr. Chairman, second question. Why is it important for the applicant to separate this land now? What's the purpose? What's the reason?
Through you, Mr. Chair. So the applicants currently lease the property from the estate, and under the terms of the will, the property is to go to a particular beneficiary, and without the severance, the applicants won't be able to purchase the severed piece and to locate their business on it.
Thank you.
Thank you.
Marcel?
Mr. Chairman, I've always had problems why the county does this all the time. They merge these properties. And if you're not aware of it, or if you don't have a good solicitor, it happens. And it doesn't mean that the people wanted it to happen, but if you're not on the ball or very sharp with what's going on, it gets merged. And I don't think that's right. If you would have a house and you buy the house next door, they don't merge it, but they'll do that with farm property. I don't think it's right.
So can we ask you a couple more questions, if we will? The subject lands that you want to sever off are being treated at this point as a separate piece of property by who? They only lease that portion of it?
They do lease the entirety of the property, and it's a bit of an interesting situation because they are tenants, but they also act sort of as caretakers of the property. They've done above and beyond, for the estate, because Mr. Smythe, before he passed away, he was legally incapacitated, so his affairs were managed by powers of attorney. So in the interim, Bill and Shalina have been maintaining the property for, they were maintaining it until as he passed, and they're looking to purchase a piece of it now.
But they only want to purchase the one section.
That is correct, yep.
What's the intention of the other section?
If I may, I have a whole presentation.
Yes?
That if I may give that first, and then if anything hasn't been answered in the course of that, then I'd be happy to entertain that at the
It
end.
might work for us.
Okay, thank you, Mr. Chair. And if I may approach, I do have one map that I'd like to pass out. Okay. Hey, good evening. Thank you, Mr. Chair, and through you, thank you to the members of the committee for the opportunity to speak to the application before us this evening. As mentioned, my name is Nathan Colomea. I'm a lawyer practicing municipal and real estate law here in Norfolk County and in the surrounding areas. I appear as agent for the applicants, Bill and Shalina Thompson, and their thriving business, Thompson Landscape Supply. My firm, Brimage Law Group, also represents the Smythe Estate, the current owner of the subject property, which has consented to the application. We appear before you this evening to ask that you approve our application to sever the lands described in the application. Notwithstanding the comments in the planning report and presentation, which I will address specifically a bit later on, our proposal is consistent with our land use planning policy framework, including the provincial policy statement, Norfolk County's official plan, and zoning bylaw. Most importantly, however, our proposal will correct a historical and inadvertent merger of two properties and allow Bill and Shalina, their business, to continue to thrive and expand on one of the corrected parcels, leading to a stronger local Norfolk economy and more jobs for our residents. You have before you the planner's report and have listed to the presentation. The planning comments begin on page 2 of the report with the review of the application of the provincial policy statement, the PPS. The report is correct in that the PPS provides policy direction on matters of provincial interest. However, the report incorrectly applies policy 2.3.3.1. The policy only applies to prime agricultural areas. And naturally, that begs the question, are we dealing with a prime agricultural area? In the PPS, prime agricultural areas are defined as areas where prime agricultural lands predominate. And prime agricultural land, in turn, is defined in the PPS. It means specifically specialty crop areas and or Canada Land Inventory Class 1, 2, and 3 lands as amended from time to time, in this order party for protection. So is it a specialty crop area? No, it's not. So that further begs the question, what class is it? And if you look, I've identified the area in which the subject property is located. I know the resolution is not the greatest, but within the circle you note that the class is 4 and 5. So in fact, that we aren't dealing with a prime agricultural area. So since the subject lands are not specialty crop lands and are not predominantly class 1, 2, or 3 lands, we're not in fact dealing with prime agricultural area, and so the particular provisions of the PPS mentioned in the report simply don't apply. Now, even if I'm wrong, and even if the PPS does apply, the proposal is consistent with it. The planning report correctly identifies that the approval of the application will rectify an inadvertent merger of two properties. It doesn't, however, give credit for the proposed use of the property, which is still agricultural. And that's where Bill and Shalina and their business, Thompson Landscape Supply, come in. Thompson Landscape Supply sells a number of products and services, but one of their main and growing sources of revenue is the production and supply of soil and soil amendments to the local agricultural community. A highlight of this operation is the production and sale of organic soil products to meet increased demand for local organic produce and specialty products for local vineyards and cannabis producers. The approval of this application will allow them to continue and expand their soil and soil amendments line, as well as the production of specialty fertilizer and feed products. The subject lands will enhance their landscape supply business by allowing them to grow sod, trees, shrubs, and other landscape products. And in addition to their business, Bill and Shalina have been farming the property itself, and they'll continue to do so following the approval of this application. So in short, the proposed use of the property is agricultural or agriculture related and is consistent with any application of the PPS. And as mentioned earlier, a second aspect of looking at the application of the PPS to the subject application is the technical and legal aspect of this proposal. So depending on how we define this, if it's a lot adjustment may be permitted for legal or technical reasons. And legal or technical reasons mean severances for purposes such as easements, corrections of deeds, quitclaims, and minor boundary adjustments, which do not result in the creation of a new lot. And we need to carefully consider the wording of that provision. It's principle of interpretation that every word in legislation, policy, has a purpose and meaning. Note that the policy section states, which do not result in the creation of a new lot. It does not state, which do not result in the creation of a lot. Something isn't new if it's already existed. And further, the purpose of much of planning regulation is to prevent unchecked development, which would result in runaway drains on municipal resources. It shouldn't and doesn't prevent the correction of the inadvertent operation of the legal doctrine of merger. The proposed severed and retained lands would simply restore the boundaries to their historical extents. The proposed severance neither expands nor restricts the old boundaries. We're not creating quote-unquote new lot. So in summary, regarding the provincial policy statement, the provisions in the PPS only apply to prime agricultural areas, and here we're not dealing with one, so the cited provisions in the PPS simply don't apply. And even if they did apply, the current and proposed use of the subject lands are agricultural, and further, the legal and technical correction of the inadvertent merger applies. So we're consistent with the PPS. And in looking at the section in the official plan noted in the report, it's important to note that the list in this section is not exhaustive. The wording of the provision is important. The first three words are technical reasons, including. The items that follow, while illustrative, are not the only technical reasons that can support a severance application. Reversing the inadvertent merger as a technical reason isn't prevented by this section. And as for the zoning bylaw, we have submitted a zoning application combined together with this severance application, which will be considered by council at a future date. And we have amended the zoning application so that it would allow for relief to address the issue of minimum lot sizes as noted in the report. And further, the report raised the issue of viability of the subject lands for agricultural purposes. The reality of modern farming is that viability is determined by what you do with the land, not just the size of it, excuse me. And as mentioned earlier, Bill and Shalina have farmed the whole of the property, being both the severed and retained lands, so they know exactly what the story is with the property. On the one hand, the whole of the property by itself, being well over the minimum lot size, simply isn't viable as a regular cash crop operation. On the other hand, combined with Bill and Shalina's business and proposed agricultural uses, even the small piece would be highly viable. Bill and Shalina's business grossed over $500,000 last year, and they're conservatively expecting to do $750,000 this year. So in fact, after a rigorous application process, including a review of the viability of their operation on these particular lands, Bill and Shalina have secured funding through Venture Norfolk to expand their operation and take it to the next level. The proposed severed and retained lands existed separately back to the 1930s and beyond, and only were merged as a result of an estate transfer back in the old registry system. And there wasn't much on title in terms of any mortgages or financing, so even though, yes, it's quite a bit of amount of time since the actual merger occurs, nothing really since then would have triggered anyone to have done something about it. And if someone would have found out about it in the 90s, they easily could have dealt with it. And even today, the two properties are recognized by two different Norfolk County roll numbers. The approval of this application would correct the inadvertent merger. More importantly, however, it's simply good planning. Approval would allow Bill and Shalina to continue to farm the subject lands, but would more importantly improve its viability by allowing them to locate their business on the property and use the property to grow and develop products for their business. Approval would improve the property's long-term viability by increasing revenues and increasing diversity of uses on the site. This proposal conforms to the PPS, Norfolk County's land use policy framework, especially when taken together with a concurrent zoning application which Council will consider. Norfolk County is Ontario's garden, and any good garden is full of growth and transformation. Please approve this application so Norfolk's own Bill and Shalina can continue to farm the property and grow their business and transform this property into something we can all be proud of. Thank you, and happy to answer any questions.
Okay, thank you. I'm sure there's some questions. Dennis?
Mr. Chairman, I'd just like to focus a little bit on this notion of creating a lot and creating a new lot. I think I heard quite clearly from the planner when the presentation was made that in the view of the planner, we were creating a new lot if in fact this merger was reversed. In light of what we just heard from Nathan, would the planner still hold that view?
Through you, Mr. Chair, we would. In terms of, we recognize that at one point they may have been two properties. However, under the current framework that we have and the provincial policy statement, it is creating a new building opportunity where one doesn't currently exist. It's a very similar circumstance, and you'll kind of recall with like the lot swaps. It's something along those same lines. The province looks at this as there's a new building opportunity where one didn't previously exist as of before this application was submitted.
And just further to that, Mr. Chair, how about the notion that the PPS speaks to prime agricultural lands? And I guess from the map that we were given today, it's pretty clear that this particular piece of land is not prime, but rather 4 or 5.
Through you, Mr. Chair. In terms of the soils, Norfolk County doesn't break down in terms of some other municipalities where you'll see a rural official plan designation versus a prime agricultural designation. Essentially anything outside of an urban area or a hamlet is considered prime agricultural lands within Norfolk County. With respect to the plan that was, or the mapping that was provided by Mr. Colmea, according to the Norfolk County information that we have regarding soils, the land does have a mix of classification from class 2 with some class 4 and 5 near the rear of the property. So in terms of that, regardless, we recognize that in some agricultural properties, it might be a little bit harder to farm, or there might be some additional limitations, but that agricultural opportunity still exists.
Dan. Mr. Chairman, could we ask Mr. Colomea to reiterate, by doing this, let me rephrase that. If this doesn't happen, can't they do? Because I thought I heard they're still going to farm the other piece, and they're going to work on this piece. So what's going to change which requires this?
So they won't be farming the other piece. So should this be approved, what will happen is that the smaller piece that's under consideration will be severed and purchased by Bill and Shalina, and that the retained parcel will be bequested to one of the beneficiaries under the will. So we'll have different owners. So they would have nothing to do with the other piece of land. And effectively what would happen is that if it weren't approved, they won't be able to buy any of the property, and they won't have anywhere for their business to go.
Dennis?
Based on what I just heard, if the owners of the property were to technically take over that piece of land we're talking about, would it be their thought to build a house on that at some point?
I can't say for certain, but just from my own knowledge of the circumstances, there is a house, while not legally on that property, it practically is. So the house that's, I don't know if you have the mapping, so there's the piece on the left we're considering the severance, and there's the retained land, and in between there's actually a little house there. So the house is owned by the family also. It's just that it's legally separate to prevent merger, funnily enough, of the house with the rest of the farm. So there is a house. Would they build there? I don't know for certain, but as far as I know, they don't have any immediate plans. But that's about the extent I can speak to the matter.
Thank you.
Anyone else?
If I may add more thing, I don't see why they would, because the house is already there. So, thank you.
However, it would be, if this goes through, it'd be possible for 2 new houses to be built on that on the overall piece of property, one on each half, right? Okay, that would be where the planning department comes to saying we're creating a new building lot. The argument is it's the old building lot, we shouldn't be there anyway. So we got to.
Mr. Chair, if may I add one more thing?
Yep.
And also consider that this is not the end of the story. This still has to go before council, and the provincial interests and all these other issues will still be considered before council as well. So we're just asking you to approve us for the first step so that we can continue along. Thank you.
Now it's going to council for zoning. Is that?
Through you, Mr. Chair, yes, the application that would go to zoning would deal with the land use to allow for the landscaping business as an additional permitted use.
I see. Okay.
Just a question on the PPS, I think. Let me find it here. Anyway, it refers to PPS 2014. So if we could ask, Mr. Chairman, was there a change between the PPS of 2014 and the PPS under which this property was merged?
Through you, Mr. Chair, yes, there would have been 2 versions from the early 90s that would have dealt with that would have dealt with provincial interests at that time. Over the years, the PPS has definitely spoken more to severance applications and has gotten more restrictive over the years. At one time, I'm sure you are well aware, there was farm retirement lots, there was infilling lots, estate lots that would have been permitted under previous versions of the provincial policy statement.
Yeah, there was one in '05. There probably was 3 different ones since then. Updated. So, but bringing up the past is fine because I wanted to bring up the past anyway. And that is, we have had over the years maybe a dozen applications where land inadvertently merged. And as far as I can remember, and planning staff, please correct me, is that we've only said no once. And that was because the guy bought the property as one big piece of property, and he owned it for several years, and then decided he wanted it to divide back into 2. But he had bought it all in one piece, so he got what he bought. So we didn't go along with that particular request. So other than that, we have done it in the past, just based on it was inadvertently put back. So that's the history anyway. Dan.
Just so that I understand, you said there were about 13, 12 went through, 1 didn't, or was it the other way around?
I said about 12. We've had about a dozen.
Yes.
I don't know exactly.
Whatever the number.
But only 1 we have said no to.
Yes, thank you.
And that wasn't based on a lot of argument. That was just based on it was inadvertent and it shouldn't have happened.
So then, Mr. Chairman, I would say that we should say no to this one as well. Sorry, we should not say no to this one as well. So let's talk about positive. Let's say yes to this one. And I would move that.
Correct. They still have other hurdles to. Yes. Yeah.
Something. I'd also like to point out that we're coming to you in good faith ahead of time. It's not as if we are operating the business on the property and we're doing this now. We're coming to you ahead of time and trying to do the right thing. So thank you.
Okay.
And Mr. Chair, if I may, I do have a copy of the draft reference plan for the subject lands now, if you'd like it.
Please, yes. Right. With that. And that coincides with our map. That's no different, right? So. Good. Okay. I forgot to turn the button on. For application BN 332, I have a motion by Dan, seconded by Larry, that we approve the application to sever a parcel of land having a frontage of approximately 203 meters, a width of 203 meters, an irregular depth of approximately 804 meters, an area of approximately 16 hectares, and retain approximately 37.6 hectare parcel as the correction of an inadvertent merging of two properties on title. I have here that the application is consistent with the policy statement and the intent of the Norfolk County Official Plan how did I go? Regarding the severance of one property into two properties to return the boundary lines to their original state to overcome an inadvertent merger of the two into one. Does that make sense? Okay, so further discussion if there is any. Those in favor of the motion to approve? Oppose? Carried.
Thank you very much.
Okay, our next two applications, BN 314 and BN 315, in the name of Marianne Paraki Phibbs. Is there anyone else here for this one? We'll have the planner explain the reports.
Yes, to the chair, I'll be presenting these two applications together, both BNPL 2018-314 and BNPL 2018-315. These are two adjacent severance applications to create two residential building lots in the urban area of Waterford. The proposed lots are each 1,054 square meters in size and front onto the south side of College Street West in the urban area of Waterford. The lands are vacant and are currently part of a larger residential property containing a single detached dwelling and a detached garage. Surrounding land uses are urban residential in nature, consisting mainly of other single detached dwellings and related accessory structures. The subject applications provide suitable infill opportunity in the built-up area of Waterford. The proposed lots are considered an efficient use of urban land, and the proposed configuration is consistent with lots in the surrounding residential neighborhood. A condition of approval for these applications is that a holding provision be placed on the lands until such a time as there is wastewater servicing capacity available. The applicants have applied for these applications prior to capacity being available because College Street West is scheduled to be reconstructed in 2019, and the applicants plan to ensure connection stubs are put in place at that time for the two severed lots, with the understanding that development on the lots cannot proceed until the servicing capacity is available. These two applications are consistent with the provincial policy statement and conform to the Norfolk County Official Plan regarding the creation of new lots. Staff support these applications and recommend that they each be approved subject to their attached conditions.
Thank you very much. Any questions of the planner? Dennis? Okay, so for application BN 314, I have a motion by Dennis, seconded by Larry, that the committee approves the application to sever a parcel with a frontage of 15.24 meters, a width of 15.24 meters, a depth of 69.2 meters, and an area of 1,054 square meters, retaining 3,076 square meter parcel as the creation of a residential building lot in the urban area of Waterford. The application is consistent with the provincial policy statement, conforms to the consent policies of the Norfolk County Official Plan, and no public input was received, therefore not considered. Any further questions? Those in favor of the motion? It's carried. Thank you. And then for BN 315, I have a motion from Eric, seconded by Rudy, that the committee approves the application to to sever a parcel with a frontage of 15.24 meters, a width of 15.24 meters, depth of 69.2 meters, an area of 1,054 square meters, retaining 2,022 square meters as the creation of a residential building lot in the urban area of Waterford. Again, it's consistent with the provincial policy statement and conforms to the policies of the Norfolk County official plan, and no public input was received, therefore not considered. Any further discussion? Those in favor? Motion is carried. Thank you. Okay, our next two applications, again, are AN 9002 and BN 9003. Dishmaker. Deshmaker. My apologies. Do you know how to say it? Okay, we'll have the planner explain the report.
This is an application to sever a parcel in the hamlet of La Salette, resulting in a subsequent minor variance application to request 270 square meters of relief from the minimum lot area and 0.71 meters of relief from the minimum required lot frontage. The subject lands are hamlet commercial and surrounded by residential and agricultural land uses. The subject lands front onto the north side of La Salette Road in the hamlet of La Salette. The lands contain an existing commercial building that was previously a general store and gas station. The underground fuel storage has been removed and soil testing is being conducted. The retained lands contain a dwelling and a detached garage. The proposed lots are able to contain servicing and are appropriate size for a new septic system. The proposal is consistent with the PPS, conforms with the OP, and maintains the general intent of the zoning bylaw. Staff support these applications and recommend that they be approved, subject to the attached conditions.
Thank you very much. Any questions of the planner? Dan moves. Eric? First one is a minor variance, and it's been moved by Dan, second by Eric, that the committee approves. The application to recognize deficiencies created through the consent application, which are 270 square meters from the minimum required lot area of 1,860 square meters, to allow for 1,590 square meter lot and 0.71 meters from the minimum required lot frontage of 30 meters to permit a frontage of 29.29 meters. In accordance with Section 45(1) of the Planning Act, the proposed development requested relief is considered appropriate, minor in nature, and maintains the intent of the official plan and the zoning bylaw, and no public input was received. Further discussion? Those in favor? And then for the severance portion, Rudy, Dennis? A motion is by Rudy, second by Dennis, that we approve the application to sever a parcel with a frontage of 32 meters, a width of 32 meters, a depth of 57.67 meters, an area of 1,860 square meters, and retain a parcel with an area of 1,590 square meters as the creation of a lot in the hamlet of La Salette. The application is consistent with the provincial policy statement and conforms to the Norfolk County official plan, and no public input was received. And conditions are included. Further discussion? Those in favor? Motion's carried. Thank you. And our next one is AN 9005. Is it Jess Hilliard? Welcome. Have the planner explain the report.
This is a minor variance application to request a front yard setback of 5.02 meters, where 6 meters is the minimum required in the zoning bylaw. The setback is for an attached garage that has already been constructed. The subject lands are 0.39 acres in size and are located at the corner of Charlotteville Road 12 West and Lindock Road in the hamlet of Lindock. The lands contain a single detached dwelling and an attached garage. The lands are surrounded by hamlet residential uses to the north, east, and south, with agricultural uses located to the west. The property has frontage on both Charlotteville Road 12 West and Lindock Road. The intent of the 6-meter front yard setback provision in the hamlet residential zone is to separate structures from roads in order to maintain front yard amenity spaces and establish a standard built form in hamlet areas, where low-density single detached dwellings are the most common use. In this instance, the small sizes and triangle configuration of the property reduce the potential building area considering the applicable setback requirements of the zoning bylaw section. The requested relief is considered appropriate and minor in nature. The dwelling on the property immediately to the east of the subject lands has a similar front yard setback to the one currently being requested. No public input was received in opposition of this application, and this application is consistent with the provincial policy statement and conforms to the Norfolk County official plan while meeting the general intent of the Norfolk County zoning bylaw. Staff support this application and recommend that it be approved.
Thank you very much. Any questions of the planner? No. Thank you. I have a motion by Larry, seconded by Eric, that the committee approves the application which requests relief of 0.98 meters from the minimum required front yard setback of 6 meters to permit a front yard setback of 5.02 meters to the existing dwelling and attached garage. In accordance with Section 45(1) of the Planning Act, the development and requested relief is considered appropriate, minor in nature, and maintains the intent of the official plan and the zoning bylaw. No public input was received. Further discussion?